the right to free and fair elections. Parties to the Convention undertake to secure Convention rights and freedoms to everyone within their jurisdiction, underpinned by the creation of the European Court of Human Rights, which deals with individual and interstate relations. My Lords, during the years following its creation, the Convention commanded widespread cross-party support. Lord Chancellors like Viscount Hailsham described it as part of, his words, the armoury of weapons against elective dictatorship. Another member of your Lordship's House, Lord Clerk of Nottingham, said pulling out of the Convention was xenophobic and legal nonsense. And on the Liberal SDP benches, notably Lords Wade, Grimond, Jenkins of Hillhead and Baroness Williams of Crosby were lifelong supporters of the ECHR. Margaret Thatcher declared that the UK was, her words, committed to and supported the principles of human rights in the ECHR. Sir John Major reiterated this commitment, and in 1998 Tony Blair incorporated the rights and liberties enshrined in the Convention in the Human Rights Act. Lord Irvine of Lairg told this House the Act does not create new human rights or take any existing human rights away. It provides better and easier access to rights which already exist. The 1998 Act was simply described as bringing rights home. And beyond our home, the ECHR provides reassurance to everyone living and travelling in the Council of Europe area that we share similar enforceable human rights standards. Now, my Lords, notwithstanding recent calls to leave the ECHR, last November this government said it remained fully committed to the ECHR and to the important role that multilateral organisations like the Council of Europe play in upholding it. The Council of Europe, of course, predates the European Union and has no connection to it. 19 member states of the Council of Europe are not members of the European Union, including the United Kingdom, with Russia expelled because of its illegal invasion of Ukraine. The ECHR and the Council of Europe are inextricably bound together. Leaving the Convention clearly means leaving the Council of Europe. Sir Jonathan Jones KC, a former Treasury Solicitor and Permanent Secretary of the Government Legal Department, says that the ECHR withdrawal would, I quote, involve leaving the Council of Europe, which is responsible for the Convention. A resolution of the Parliamentary Assembly of the Council of Europe states that accession to the Council of Europe must go together with becoming a party to the European Convention on Human Rights, while the European Court of Human Rights insists, today more than ever, the Convention is the cornerstone of the Council of Europe, and any state wishing to become a member of the organisation must sign and ratify it. Now, last month, Theodoros Rousseau-Poulos, the current President of the Council of Europe, of the Parliamentary Assembly, gave a Lord Speaker's lecture. We heard him pay tribute to the commitment and to the high-level contribution of the United Kingdom parliamentary delegation led by the Noble Lord, Lord Tuig. To those who today will demand that we leave the ECHR and therefore the Council of Europe, I would simply ask them to tell us which rights of the Convention they object to. Do we really want to join Belarus and Russia as the only countries not part of any pan-European body? My Lords, in 2001, Parliament created the Joint Committee on Human Rights, which I have the honour to chair, although today I speak for myself and not the committee. But the committee has a remit to examine matters relating to human rights in the UK, and it's historically functioned as a champion for convention rights. The JCHR pays close attention to the cases before the European Court, whose judges are elected by the Council of Europe's Parliamentary Assembly, and we've noted the role of the Convention and the Court by way of example. For instance, by ending the ban on gay people in the military and homosexual criminalisation in Northern Ireland, in prohibiting the retention for life of DNA samples of innocent people, on indiscriminate phone tapping, on the plight of the Sunday Times when they were prohibited from publishing information about thalidomide, on the protection of vulnerable victims of domestic violence, on the combating of racism, and to the degrading punishment of a teenager in the Isle of Man. Among our current JCHR inquiries, we're examining the failure to prosecute UK nationals who took part in the genocide in Iraq, for transnational repression and forced labour in supply chains, and previous inquiries included reform of the Human Rights Act and the right to family life. Last week we held a round table on the mental health bill, where we heard stories of detention and incarceration. And earlier this week, my lords, I met with Volker Turk, the United Nations High Commissioner on Human Rights, to discuss what we actually mean by human rights and how deeply they are connected to the laws we proclaim, the conventions we have signed, and the traditions of liberty and freedom represented by this place. The European Convention on Human Rights is an essential part of that tradition. Malcolm Bishop KC, writing in the New Law Journal, says, "The Convention is now firmly embedded in the common law, and an impressive corpus of jurisprudence has emerged, which, in my opinion, has made this country a better place." My lords, I agree. To its detractors, and for the record, in 2024, the court gave just 2 judgments on the merits of cases involving the United Kingdom. A violation was found in one case, and no violation was found in the other. In a commentary earlier this week, Joshua Rosenberg forensically addressed the caricatures and the misattributions which are often wrongly laid at the door of the ECHR. By population, the UK has the lowest number of applications of all member states, 3 per million people, while for all states combined, it was 47.4 per million. The reason, of course, why there are so few UK cases is that broadly we obey the ECHR. Those who want to reduce UK legal standards, and some even, of course, want to tear up the Human Rights Act, would vandalise our constitutional settlement. This, and leaving the Convention in a fit of pique rather than engaging and reforming it, is not worthy of this country or those who entrusted this extraordinary legacy to us. At the outset of my remarks, I recalled Kierkegaard's thought that life can only be understood backwards, but it must be lived forwards. Institutions and conventions are not set in stone. There's always scope for political debate and greater definition of the respective role of parliaments and judges around controversial issues such as border control, an issue which the JCHR will examine. But to throw away all the games would make no sense and merely play into the hands of dictators and enemies of democracy. We're experiencing war in Europe, along with contempt and disregard for international law and institutions, including despicable attacks on the International Criminal Court. We see the rise of autocracies with global reach, even with reach into the UK through transnational repression by hostile states. Rights and freedoms are under assault from within and from without. And in this context, we are therefore right to recall the spirit which 75 years ago animated remarkable leaders. We're entitled to have pride in the significant British contribution in creating both the Universal Declaration of Human Rights and the European Convention on Human Rights, genuine pride in the development of human rights, international law, and the protection of fundamental rights and freedoms. To defend this legacy, my lords, we must become far more robust in the public domain, in our schools and in our universities, in setting out the patriotic case for these shared fundamental values. In this 75th anniversary year of the European Convention on Human Rights, we are entitled to look back on what was achieved in the ruins of Europe, out of the ashes of Auschwitz. My lords, we must insist that those concerns remain vitally relevant to this day and that they are crucial to our future. I beg to move.
The question is that this motion be agreed to.
My Lords, I declare interests as the author of the Penguin Allen Lane book, Human Rights, the Case for the Defence, as a new member of our delegation to the Parliamentary Assembly to the Council of Europe, and as a lifelong human rights lawyer and campaigner. I must congratulate the noble Lord Alton on such a well-deserved appointment as chair of the Human Rights Committee, and for that outstanding opening of his debate, marking the 75th anniversary of the convention which protects the civil rights of around 700 million people in 46 states. I've been working with the convention on an almost daily basis for around 30 of those years. both for and against UK governments, domestically and in the Strasbourg Court, that has rendered it perhaps the most effective international human rights mechanism in the world. Most formatively, I was a government lawyer in the late 1990s during the passage and implementation of our Human Rights Act, and at Liberty, the National Council for Civil Liberties, from 2001 until 2016. And we've been so eloquently reminded of the history of why conservative politician, jurist and Nuremberg prosecutor David Maxwell Fyfe was deputed to lead the convention drafting process after the Council of Europe was founded by the Treaty of London in 1949. My Lords, if there were ever any doubt about the direct relationship between justice and peace, the 1930s had ended it. And this was especially so in Europe, where two proximate world wars had begun. It could be no surprise that those seeking to rebuild the lands of Milton, Molière, Mozart and Michelangelo should have made cooperating around human rights enforcement a priority. If we've sometimes been a little complacent in the intervening years, surely that is over now, as war and far-rightism once more stalk Europe, and respect for the rule of law is far from secure, even in that great old constitutional democracy across the Atlantic. In any event, I can report firsthand of the many ways in which the Convention has come to the aid of people in the United Kingdom, where both their common law and their legislators had previously failed them. Before Strasbourg intervention, my Lords, victims of rape were subjected to days of degrading cross-examination in person by their alleged assailants, contrary to Article 3. Similarly, abusive parents who beat their children to a pulp could be acquitted of the grave offence of causing grievous bodily harm by deploying the defence of reasonable chastisement of a child. Indeed, I'd go as far as suggesting that victims of crime may be amongst those who have most benefited from the Convention effect upon our domestic law. Before and since, the Human Rights Act 1998 brought rights home to be directly enforceable here. My Lords, there are numerous examples too of the UK's privacy, free speech, non-discrimination and other vital rights and freedoms being ensured and enhanced by the Convention. It would be far from liberal or progressive, and certainly deeply unconservative, not to treasure it.
Yeah. I congratulate the noble Lord Alton, for whom I have enormously high regard, on securing this debate and his introduction to it. It's a paradox that defenders of the supranational European Court of Human Rights invariably begin by an appeal to British chauvinism laced with deference to conservative icons, by invoking the creation myth. That goes as follows. The ECHR was a British invention inspired by Churchill, drafted by Maxwell Fyfe, which codified historic British rights, and since we were the first country to ratify it, must have been eagerly endorsed by us. Unfortunately, that's almost entirely false. Attlee's government ratified the convention with great reluctance and only on condition that the future European Court would have no jurisdiction in the UK, since British people would not be allowed to take cases to the court. They also treated the convention as non-binding, deliberately not altering laws known to be incompatible with it. Moreover, when Churchill returned to number 10 a few months later with Maxwell Fyfe, now Lord Kilmuir, as his Lord Chancellor, despite some ambiguous enthusiasm for it in opposition, he adopted exactly the same position as Attlee, as did subsequent Conservative Prime Ministers, not allowing the court jurisdiction in the UK. The second myth about the ECHR was that it simply codified British rights, which had evolved over centuries. If that was all it did, British membership would confer little benefit and leaving would be no loss. This myth implies that few British laws will be incompatible with the Convention, if only. Judgments have been made in 567 cases, and the UK found to be in violation in one or more respects in no fewer than 329 of them by the Strasbourg Court. In addition, the Court has decided over 25,000 British cases by rejecting or declaring the vast majority inadmissible, but after enriching the lawyers. And that would be no surprise to those advising Attlee's government, who warned that allowing recourse to Strasbourg would, and I quote, provide a small paradise for some lawyers, now among its most enthusiastic supporters. In the immigration and asylum tribunals alone, human rights cases were 40% of the 350,000 cases received over the last 8 years. To say it has no impact within the UK is an absurdity. The original purpose of the European Court was not to fine-tune each country's statute book, but to protect fundamental freedoms from torture, slavery, arbitrary arrest, etc. The third myth is that the Court has succeeded in this objective. It was always unrealistic to imagine that any regime which was prepared to use torture, slavery, or arbitrary arrest would be put off by the prospect of an adverse ruling by a foreign court. In practice, whenever an authoritarian regime has come to power, adherence to the ECHR has not dissuaded them from trampling on human rights. When the Greek colonels faced an ECHR ruling about the use of torture, Greece simply withdrew from the convention. Russia was expelled for the full-scale invasion of Ukraine, not for its rampant domestic human rights violations. Belarus abandoned its observer status rather than implement convention rights. Both Azerbaijan and Turkey have gone pretty far down the road to authoritarian regimes, while still remaining in the convention. One reason France, this is little known, didn't even ratify the convention until 1974 was that it was aware of the use of torture and other abuses of human rights during the war in Algeria, and had other reasons afterwards for remaining outside. Indeed, it didn't allow its citizens to take cases to Strasbourg until 1981, but suffered little opprobrium for doing that, or not doing it. The claim that if Britain left, it would be joining Belarus and Russia is puerile. We will be joining other common law countries, democracies, Australia, New Zealand and Canada, who uphold human rights without relying on a supranational court. Like them, we would make our laws democratically, not hand over the right to make laws to an international court, giving it power to legislate rather than enforce the law.
Very good.
My Lords, I congratulate the noble Lord Alton for his excellent opening to this very important debate. When Ernest Davis, the Member of Parliament, signed the convention on behalf of the Labour government in 1950 at Rome, he was not carving a monument in stone. He was putting his name to a dynamic and living convention. There were 15 signatories. Now there are 46, excluding any Belarus and Russia in the European context. The Guide to the European Court puts it this way: by its case law, the Court has extended the rights set out in the Convention such that its provisions apply today to situations that were totally unforeseeable and unimaginable at the time it was first adopted. New technologies, bioethics, the environment. The Convention also applies to societal and sensitive questions relating to terrorism or migration, abortion, assisted suicide, body searches, domestic slavery, adoption by homosexuals, the wearing of religious symbols, the protection of journalist sources, or the retention of DNA data. What happens where there's no European Convention? Last week in the United States, hundreds of Venezuelans were shipped to El Salvador. They were treated in an inhuman and degrading manner that would contravene Article 3 of the European Convention. They were shackled, Article 5, without any form of trial. Article 6, no ability to complain to a court of the violation of their rights. Article 13, the USA is a country which bows the knee to Magna Carta and the rule of law. But the US federal judge who sought to block this move has been ignored. Oopsie, too late, said the president of El Salvador, pocketing the millions of dollars paid to his country. Where have we seen this behavior before? Nazi Germany, whose crimes motivated European countries to come together to sign the convention. And there's a suggestion by the noble Lord Lilly and others that the UK should withdraw and write its own, presumably on the Trumpian model. But there is good news. The Human Rights Act came into force in the year 2000. Since then, there have been 245 judgments against the UK, finding at least one violation of the Convention. But the number of cases has steadily declined, from 18 per year at the beginning to just 2 in 2022. And the number of applications, as the noble Lord Alton pointed out, against the UK was the lowest per capita now of all European states. So we have succeeded in bringing the convention home, as Baroness Chakrabarti pointed out, so that our own courts can and do apply its provisions in appropriate cases. 3 reasons. First, the Human Rights Act creates a legal obligation for all public bodies, including the police, hospitals, care homes and local councils, to protect rights in all their decisions and actions, meaning that people's rights are less likely to be breached in the first place. Secondly, United Kingdom courts are now the first port of call for any human rights claimant, and United Kingdom judges consider human rights more explicitly and intensively than they could before. And thirdly, the European Court is much more likely today, in considering applications from this country, to follow the reasoning and conclusions of our courts and the decisions of our public authorities. It respects our judges in the way in which the Human Rights Act is applied. Ernest Davis, Ernie Bevin, Clement Attlee were right to feel proud of what they had done.
My Lords, I too would like to add my thanks to the noble Lord Alton for his for getting this debate and for his speech. I'm not going to explore the legal implications. I want to make a few theological points, if I may. I want to comment on the origins of where we've got to, that spring where the ideas came first from, how it developed into a stream and a river, and how still today our understanding of rights and indeed responsibilities is developing. The noble Lord Lilly is right. It starts going back to those early chapters of Genesis. Well, in fact, you could go back to the Code of Hammurabi, 1700 years before Christ, but let's go back to the Ten Commandments, where we find the creation narratives where humankind is created in God's image. It's about the inherent dignity that belongs to each and every person, not dependent upon sex, wealth, education, or any other differentiation. This is implied in the Ten Commandments and is developed further in passages such as Deuteronomy 10, where God defends the cause of the fatherless and the widow and loves the stranger in the land. It's why the prophet Isaiah urges the people of God to seek justice, correct oppression, defend the fatherless, plead for the widow. However, as Jonathan Sacks, a former member of your Lordship's House, was keen to point out, rights are things we claim, duties are things we perform. In other words, duties, he said, are rights translated from the passive to the active mode. The biblical teaching in the New Testament reaches its fullest expression in this reciprocity in human relating, expressed by Jesus that we should love the Lord our God with all our heart, soul and mind, and love our neighbours as ourselves. Now, of course, nowhere in the scriptures do we find the phrase human rights, and certainly no reference to the ECHR. Indeed, some theologians, such as the eminent Alistair MacIntyre, have argued that human rights actually are a fiction. He simply didn't agree with them as a concept. But others, including a former member of this House, the noble Lord Williams of Oystermouth, disagreed, and I quote, "The fundamental theological point is not so much that every person has a specific set of positive claims to be enforced, but that persons and minority groups of persons need to be recognised as belonging to the same moral and civic world as the majority, whatever differences or disagreements there may be. He went on to argue, and I quote, "A proper consideration of human rights has a better chance of sustaining its case if it begins from the recognition of a common dignity or worthiness of respect among members of a community than if it assumes some comprehensive catalogue of claims that might be enforceable." My lords, all laws, indeed, and all conventions are ultimately human constructs. And there are, of course, some who dislike the ECHR and indeed have problems with the whole wider issue of human rights. And there are, of course, people who are not happy with the way that the court has interpreted the underlying legal principles which are enshrined in the Convention. But, my lords, the huge benefits it has brought to so many people, particularly to people who've traditionally been marginalised and have not been given the ability to participate and to engage, surely outweighs the frustrations that sometimes people feel. I, for one, am thankful that we have the ECHR.
My lords, as your lordships will know, and as I'm sure the Right Reverend Prelate, whom it is a pleasure to follow, will know, in George Orwell's 1984, three great regional powers, Oceania, Eurasia, and Eastasia, confront each other with constantly shifting alliances. Why those alliances shift is never clear, but it's the people and their human rights that suffer. Today, there is, of course, a fourth great power in the world, not only the United States, Europe in a rather different form from the others, and Russia, but China too, watching and no doubt considering its options for Taiwan. One cannot, of course, push analogies too far, but we do now live in a world of great power machismo, where international cooperation and international agreements are too often flouted. But it is precisely at times like these that they are so needed, and why it is right to focus now on the European Convention on Human Rights. Too often, Europe, which we like to think of as civilized, has experienced the abuse of human rights. In Ukraine today, in the aftermath of Russia's wholly unjustified and unjustifiable invasion, in Bosnia, in Serbia, in Kosovo 20 years ago, in the chaos and anarchy of Eastern Europe after the Second World War, brilliantly evoked in the books of Primo Levi. It's a tribute to the ECHR that more than 40 countries, with Russia of course expelled, are now its members and have accepted the international legal obligation to protect human rights, in our case, through the implementation of the Human Rights Act. Of course, the ECHR is not perfect. Of course, some member states fail to observe all their obligations under it. But Europe, and through Europe's example, other parts of the world, are the better for it. As an original signatory, Britain gained respect and influence. As a constructive and active member, that must remain the case, so that Britain can help realise the ECHR's principles. So I do not favour withdrawal from the ECHR. I believe in exercising our influence for good within it. I am glad that the Prime Minister has said that the government is unequivocally committed to the UNHCR. I hope that the noble lady, the Minister, will repeat that commitment today.
Yeah. My Lords, I I want to, first of all, make my own declaration that I'm a practitioner at the English Bar, but I'm the President of the Council of Justice, which is a leading British law organisation. I'm the Director of the International Bar Association's Human Rights Institute. I'm an honorary writer to the Signet in Scotland, and I, as you heard earlier, I'm currently working for President Zelensky, heading up with his chef de cabinet a task force to try and get the children back from Russia, and have been working on that for a number of years with the Yale Observatory and other bodies. I want to thank Lord Alton. We owe him a debt of gratitude in this House for his constant reminders to us of our common humanity, and he is tireless in his work on the abuses that happen around the world. And so it's no surprise that he is speaking here in protection of the values of the European Convention on Human Rights. It amazes me that the very same people who fought tooth and nail to take us out of the European Union, a step which has been ruinous for the economy of this country, are still seeking to sever ties with our European neighbours, especially when it's at this moment in time when it's clear that we have to retain our bonds of connection with Europe and European nations in the face of grievous threats from Russia. The withdrawal from the European Convention would be really disastrous. The Human Rights Act has enriched our law enormously, and it has been especially productive for women. And I say that as someone who has been very much at the front line in cases concerning the rights of women. And you only have to think about the case of war boys, where it was possible to use it before the courts to make sure that rape was properly recognised in prosecutions. The vulnerability of victims of domestic violence have received better protection because of the Human Rights Act. The ending of the ban of gay people in the army, the inquiry into the sex abuse of women in the army, and the better protection of children against corporal punishment, also against sexual abuse, the greater protection of the media, the ending of detention without trial at the beginning of the 21st century, the prevention of torture from other countries being used and evidenced in our courts, the protection of religious freedom. I mean, the list is enormous, and it's been vitally important in the Northern Ireland peace process. And I just ask this question: you can't pull out of the ECHR without leaving the Council of Europe. This alliance promotes democracy, human rights and the rule of law across 46 states. Since its inception, the Council of Europe has accepted over 200 treaties, conventions and protocols, including the Istanbul Convention to end violence against women and girls and to end domestic violence, the Lanzarote Convention on protecting children from sexual exploitation and abuse, and the Council of Europe's Convention against human trafficking. The Council of Europe carries out work to promote and defend. I hear the muttering on the front benches across the way, but really we should remember the work that's done through the Council of Europe defending local and regional democracy and governance, observing, going, and I've done it myself, going and observing elections and promoting good governance through the exchange of experience amongst member states. The Council of Europe also helps member states fight corruption and terrorism and undertakes necessary judicial reforms. It has a group of constitutional experts known as the Venice Commission, which offers legal advice to member states. Are we going to pull out of that? In the face of Russia's ongoing aggression, the Council of Europe is supporting the people of Ukraine. The Council of Europe has a dedicated Ukraine action plan. And the Council of Europe has a development bank which is aiding Ukraine in its recovery efforts and accommodating Ukrainian refugees. Are we really going to put all of this at risk? Are we really going to reduce ourselves to little Englanders? Because that's what it would mean, because the people of Scotland, the people of Northern Ireland and of Wales do not want to leave the European Convention on Human Rights.
Lords, while congratulating the noble Lord Alton on securing this debate, I begin by paying tribute, as he and others have done, to one of the ECRH founders and drafters in 1950s, Sir David Maxwell Fyfe, later as Viscount Kilmere from 1954 to 62, to be Lord Chancellor here under Judicial, Eden and Macmillan, and who earlier on at the Nuremberg trials, through his fair-minded skill and clarity as a prosecuting counsel, played an enormous part in enabling the German public to understand and accept the guilt of their leaders for crimes against humanity, his cross-examination of Hermann Göring becoming one of the most noted in history. And I join with your lordships in giving huge thanks to ECHR, whose 75th anniversary we now commemorate, for the extent to which, in healing wounds with balanced purpose, and has already implied by the Right Reverend Prelate, the Bishop of St. Albans, it has also reinvigorated the heart, mind and soul of Europe, yet furthermore for its success in providing soft power direction and stability well beyond Europe and throughout the world, thus with efficacy accomplishing what was intended of it in the first place, as expressed by Maxwell Fyfe in Strasbourg in August 1949, and I quote, "We cannot let the matter rest at a declaration of moral principles and pious aspirations, excellent though the latter may be. There must be a binding convention." My lords, in my remarks today, I will very briefly touch on three aspects: the scope for the United Kingdom to achieve results through the Council of Europe, education as a human right, and the practicalities of its delivery. During the progress of the Data Use and Access Bill, your lordships will recall that this House voted to protect private copyright under Council of Europe standards, yet in which regard we can still proudly reflect that in the first place, the present copyright protection ECHR conventions are themselves precedented and inspired by the United Kingdom in 1710, 3 years after the 1707 Act of Union, and through the Statute of Anne, which granted publishers of books legal protection. Particularly so to our advantage here, as a revising change, and as emphasised by Noble Lord Alton and others, countless examples come to mind of the Council of Europe as a natural ally, within which affiliation of 46 states, the United Kingdom remains a prominent member, and where I'm in recent chairman of its Committee for Education. As we are all well aware, the numerous groups of people suffering disadvantage in education range from girls and women, students with disability and special needs, learners living in remote areas, refugees and asylum seekers, to those experiencing discrimination against them from a number of pretexts and prejudices, and not least those living in countries where educational systems are insufficiently developed. During its G7 presidency in 2021, the United Kingdom gave a commitment to promote education in the Third World and elsewhere as necessary. What actions have the government taken since then? Which initiatives are in progress? Can the noble lady, the Minister, affirm that such G7 plans are being clearly designed and carried out so that they contribute towards building up the strength of international communities themselves? What plans do the government have, along with international partners, including the Council of Europe, to coordinate the delivery of a variety of international education initiatives which are at risk of financial cuts? As well as students, clearly such interventions stand to benefit communities, cities and regions as well. One example is the current academic partnership of joint research into green energy between the Scottish University of the Highlands and Islands in the United Kingdom and the University of Zadar in Croatia. Having helped to put this together, I declare an interest as current chairman of the all-party parliamentary group for Croatia. What steps are the government now taking actively to encourage similar partnerships, possibly facilitated by Horizon and other schemes? Lords, following ECHR and education as a human right, enhanced prospects for world peace will also derive from much better education and competitive skills opportunities at grassroots and within all international communities. Given that G7 countries have already embraced that objective, the United Kingdom, in its own interest and that of others, must now help to ensure that this objective is properly carried out.
Lords, about 10 years ago, as a minister, I visited the European Court of Human Rights in Strasbourg. I was there to apologise to the Committee of Ministers for the fact that we had not yet given prisoners the vote. While I was there, the President of the Court kindly gave me a book about the Convention and the Court, entitled The Conscience of Europe. It was a fascinating account of the establishment of the Court and its development for the subsequent 65 years. But it is important, of course, to remember the context in which the Convention was born. The noble Lord has given a very vivid account of that. a continent devastated by war in which the population had been deprived of all the most basic human rights. But did the architects of the ECHR really envisage that an asylum seeker here would be able to rely on the Convention when arguing that his children's liking for chicken nuggets meant that he should not be returned to his country of origin, because to do so would violate his human rights? This and so many other cases have trivialised human rights and are not reflective of the legacy of those responsible for the Convention. My Lords, I should declare an interest as a member of the Commission on the Bill of Rights set out by the coalition government. Of perhaps more importance is the fact that since the 1998 Human Rights Act came into force, I have regularly acted for public authorities. Time does not permit me to give a full list of all my failures. I was recently reminded of one. A group of prisoners sought damages on the basis that their human rights had been violated because they were not given heroin whilst in prison, a breach apparently of Article 3. I acted for the police because a number of Nigerian young women living in this country had been kept in domestic servitude by some rather richer Nigerians. The court was asked to find, and did find, that the police were guilty of a violation of human rights for not being sufficiently curious, not the girls' captors, the police. My Lords, I'm extremely reluctant to suggest leaving an international institution of any sort. We know they are rarely perfect, but it's surely better that they exist. I'm particularly conscious of the importance of remaining on good terms with our European allies, particularly at this moment. I voted to remain in the European Union. But I've come to the conclusion that at the very least we should repeal the Human Rights Act. The obligation in that legislation to take into account Strasbourg jurisprudence has produced some very unsatisfactory results. The process of taking it into account can itself be difficult given the variable quality of some of the judgments. What it has meant is that we pay far greater heed to the court's decisions than any other countries within the Council of Europe, a particular irony since there are so few decisions actually against us, the United Kingdom. This government has an almost theological approach to the ECHR and the HRA, but critics of the way it has operated in practice are not confined to those on the right, as noble lords may have observed. My view is that Parliament and the courts are not only capable, but better suited to protecting human rights here, rather than our current arrangements, which amount to a significant subcontracting of the task to an international court. I, like others, am most grateful to the noble Lord Alton for bringing this debate to your Lordship's House. With his passion for the protection of human rights, he would have made a great contribution to the ECHR had he been around at the time. Indeed, he would have been a worthy guardian of the conscience of Europe. It is thus a matter of profound regret that I must express the view that the whole concept of human rights has been brought significantly into disrepute.
My Lords, I spent 21 years as a barrister and then 5 years as a judge, arguing and applying English law while the rights contained in the Human Rights Convention were not part of our law. Then from 2001, shortly after the Human Rights Act came into force, I spent 16 years as a judge applying and developing our law so that it incorporated convention rights. Across the UK legal system, whether in civil law, public law, criminal law or family law, the Human Rights Act introduced important new rights such as the right to privacy and family life. It reinvigorated many previously stultified rights such as freedom from detention. It re-emphasized the importance of vital rights such as freedom of expression, and it increased the rights of all citizens against excesses of the state, a particularly important feature at the time of ever-increasing regulation. My Lords, I'm no starry-eyed human rights groupie. As a senior judge, I tried to ensure that the new human rights jurisprudence did not cause the common law, of which this country should be so proud, to wither away. Rather, I tried, and I hope together with my colleagues succeeded, in ensuring that the judges developed the common law so that it incorporated and benefited from the principles of the Convention. Of course, human rights law can occasionally lead to results with which many people will disagree. But application of established law in any field can result in unpopular decisions, and that's a particular risk with a law which paints on such a very broad canvas. Many decisions which are unpopular in this connection are concerned with asylum, and this country's international duties with regard to asylum seekers are controlled as much by United Nations treaties as they are by the Convention. And there is a real danger that the public get a warped view of human rights, with the media focusing on cases which can be portrayed as leading to surprising results. Many of those cases are inaccurately or very one-sidedly reported, and while there are a number that are not unfairly or inaccurately reported, they should be contrasted with the many, many unreported decisions where human rights have enabled or assisted a judge to get a fair answer which otherwise he or she may not or could not have done. And in a number of cases where the result does seem rather odd, I am sometimes rather surprised that the government or the relevant public body has not chosen to appeal. Judges don't always get things right, and appeal courts are there to deal with that. And too often there are no appeals when there should be. 46 countries have signed up to the Convention. It's a civilized force in an increasingly unstable world. Because its decisions apply over so many countries, the Strasbourg Court judges generally appreciate that they have to tread carefully when laying down the law. They've developed the concept of a margin of appreciation to enable individual countries to make their own rules in some sensitive areas, like assisted suicide. And in my experience and knowledge, the Strasbourg judges have been prepared to reconsider, to go back on decisions when a UK court has given judgment explaining why they think that a particular Strasbourg court decision may be inappropriate for the UK. This country is almost unique in the world in having no coherent, overarching constitutional document. Because of the Human Rights Act, because of that, the Human Rights Act has a particularly important role in protecting individual freedoms and liberties. It has been very cleverly drafted so as to give human rights a special status in our Constitution without overriding the supremacy of Parliament. We should be valuing it, not trashing it.
I draw the attention of the House to my registered interest. I am a partner at the Good Faith Partnership, which provides the Secretariat for the UK Forb Forum. I thank the Noble Lord Oulton for this debate, and as other Noble Lords have noted, for his tireless commitment to human rights. He has long been an inspiration to me personally, and as a new member of the House, I hope to become more like him when I grow up. I wish to draw Noble Lord's attention to the importance of the European Convention on Human Rights for the pursuance of freedom of religion or belief. Born amidst the growing realisation of the full and horrific extent of the Holocaust, the issue of freedom of religion is core to the Convention. Everyone, Article 9 declares, has the right to freedom of thought, conscience and religion. Sadly, the fight for religious freedom is far from won. More than 80% of the world's population live in states where there are severe or significant restrictions upon their freedoms, and that number is rising. And while the continent is home to the Convention, there remains work to be done and threats to guard against. A few years ago, I sat in the gallery of the Bundestag witnessing the understandable anger and outrage of the majority of its members as one party repeatedly refused to condemn the internment of Uyghur Muslims in so-called education camps in China. Watching this scene play out in that place was chilling, to say the least. I am grateful for the leadership of our government in this area, for the work of my noble friends Lord Collins of Highbury and Baroness Chapman of Darlington, and for the appointment of my honourable friend David Smith MP as the UK's Special Envoy for Freedom of Religion or Belief. I am certain that they will build on the work of the Noble Lord, Lord Ahmed of Wimbledon and previous envoys, and ensure that we as a country remain a leading force for freedom of religion or belief around the world. Finally, I would ask the Minister to take this opportunity to assure the House of this government's continued support for the court that upholds the Convention. As the Noble Lord Alton made mention, the European Court of Human Rights has only once found the UK to be in breach of Article 9. We can certainly be proud of our record. We must continue to hold ourselves to the highest standards. We must make ourselves accountable for our decisions and actions. The challenge to reduce persecution around the world is beyond the powers of any one country. At a time when intergovernmental institutions are all too often and all too easily undermined, the Court and its Convention offer a unique opportunity for nations and institutions to work together and fashion a world where people are truly free.
My Lords, it's a privilege to serve on the Joint Committee of Human Rights under the chairmanship of the Noble Lord Alton, whose timely debate this is and whose contribution we heard earlier. As a barrister practicing in part in the field of public law and human rights, and as a member of the Joint Committee on Human Rights, and like all noble lords who've spoken, I place the highest values on human rights. However, human rights are not one and the same thing as the European Convention on Human Rights as it is today. In March 2021, the former Professor of Law and Legal Philosophy at the University of Oxford, John Finnis, and I wrote a paper for Policy Exchange entitled Immigration, Strasbourg and Judicial Overreach. In his foreword to that paper, the Noble Lord Hoffman noted that there is only one way to determine the limits of the commitments undertaken by states which subscribed to the European Convention on Human Rights, and that is by reading the instrument and construing it against the background which would have been known or assumed by the parties at the time. Indeed, this is the only way to understand the meaning of any utterance whatever. But the European Court of Human Rights have felt free to give the Convention a meaning which could not possibly have been intended by its subscribers, on the ground that it is a living instrument, which it is entitled, indeed required, to update in accordance with what it considers to be the spirit of the times. In the paper, we examine the transformation of the Convention from, in respect of immigration policy, the position in 1951 being that the signatory states had no obligation to let in refugees, had no legal or treaty obligation to accept refugees at all, and had no absolute obligation to continue to provide asylum for refugees who are a danger to the community. They were matters for the states themselves. 40 years later, the European Court of Human Rights set out a line of judgments which has circumvented those principles. It has done so along two routes. The first gives the ECHR's absolute prohibition of torture and inhuman treatment found at Article 3, a radically expansive interpretation which is neither morally nor legally warranted. The second circumvention has been via Article 8, the right to a private and family life, which has been expanded to override immigration controls, something which those who drafted, signed and ratified the Convention would certainly have rejected. These misinterpretations facilitate unlawful migration, incentivize it, and hamper European states in justly handling the issue. Elastic, expansive, and inauthentic treaty interpretations such as these are contributing substantially to the real risk that the rule of law in European states will be overstrained. Behind this judicial transformation of refugee and migration law lies the doctrine, judicially invented in 1975, that the ECHR is a living instrument. This doctrine enabled the Strasbourg judges to reform social arrangements, even very fundamental ones, either without debate and approval from democratic legislatures or with a retrospective approval strongly encouraged by the court's assertions that these reports are already required by law and by international agreements and obligations which this country has long accepted as binding. In either form, my lords, this is an unconstitutional purpose. It is unfitting for the ECHR The convention was intended not to provide an engine for social reform, still less for top-down reforms, but to block regression from the level that the respect for rights that was in 1950, that was standard in 1950 in the founder states, distinguished from the defeated fascist states and the communist tyrannies imposed on Europe in the late 1940s. My Lords, the calls for withdrawal that we have seen from, in relation to the Convention come about as a result of these issues, and I submit that this House will expect to see the European Convention on Human Rights either reformed or face a clamour which may be unavoidable.
My Lords, I want to congratulate Lord Alton for securing this important debate on the 75th anniversary of the European Convention on Human Rights, and I echo Lady Kennedy's remarks about the important contribution that Lord Alton has made to human rights over many years. I declare my interest as a delegate to the Parliamentary Assembly of the Council of Europe and a member of the PACE Committee on Legal Affairs and Human Rights. I'm also the chair of the Human Rights Committee of Liberal International, which is a designated NGO to the UN Council of Human Rights. In following the Noble Lord Murray of Blidworth, I have to say I didn't agree with his views, but I am grateful that he and I are both free to say those things that we wish to, which millions elsewhere in the world are not, because they do not have the human right, freedom to do so. My Lords, others have already explained the creation of the European Convention and the role of the Council of Europe in the establishment of the creation of the European Court of Human Rights. PACE appoints the judges, takes evidence on key matters relating to human rights, and it's also able to bring states together to address failures, even, or especially, PACE's own member states. PACE meets in 2 weeks' time to address the new Georgian government's breaches of human rights following its elections last year. Every day, many thousands of peaceful protesters come together across Georgia to remind the new government that their elections were not democratic, that new laws enabling imprisonment for the most minor offences, the extrajudicial murder of journalists and imprisonment of civic leaders, including artists, actors, journalists and politicians, continues. As a result, PACE must decide whether to recognise the credentials of the Georgian Dream Party, given these human rights infringements. And as Lord Alton mentioned, PACE has done this before. Following the 2022 invasion of Ukraine, PACE did not recognise the Russian delegation, and Russia was expelled. UN Watch, a Geneva-based NGO whose mission is to monitor the performance of the UN by the yardstick of its own charter, made the case in April 2022 to the UN General Assembly that following the murder of civilians in Bucha, Ukraine, Russia should be suspended from the Human Rights Council. It is completely wrong to be overseeing the protection of human rights whilst clearly abusing them, and they were suspended by a 2/3 majority. Similarly, following the murder by Iranian police of women's rights activist Mahsa Amini in 2022, the UN Economic and Social Council suspended Iran from the Commission of the Status of Women until 2026. My Lords, these two cases are important. The UN is a body of states that rarely agrees on everything, but occasionally, with outrageous breaches of human rights, it is important that action is taken. And these two states, as well as China, are now using extraterritorial action, a sadly growing area of human rights abuse. Putin's murder of Litvinenko in London, the attempted murder in Salisbury of Sergei and Yulia Skripal, and the murder of Dawn Sturgis, a completely innocent bystander, making the UK and its people at risk from human rights infringements by other states on our own territory. China, like Iran and Russia, also follow and monitor exiles abroad and the families of those who fled. The threat to their safety is real. In July 2023, the police in Southampton charged a Chinese national student with racially motivated assault after he and others assaulted a Hong Kong man on the street. And that same month in Southampton, footage emerged showing pro-Hong Kong demonstrators being violently attacked by a group of Chinese nationals. So can I ask the Minister, are our frontline police being trained to recognise this extraterritorial action by other countries? And are the individuals at risk being given support and protection? And are we working with other countries and the Council of Europe on how we tackle this particularly egregious threat to human rights?
My Lords, I too wish to thank the Noble Lord, Lord Alton of Liverpool, for so powerfully moving this debate with such a comprehensive and passionate opening statement. It gives us the opportunity to note the tremendous positive impact of the Convention, not only here in the United Kingdom, but elsewhere. I too wish to record my thanks to Professor Paul Johnson of the University of Leeds for his advice and support. My Lords, the Convention is a vital aspect of life in the United Kingdom. It does not merely enunciate a set of important principles that most of us agree with, such as the ability to speak freely, to hold our own beliefs, and to be free from interference in our private lives, as others too have said. But rather, it creates a tangible and effective mechanism to allow all of us to seek redress if we feel our human rights and fundamental freedoms have been violated. The sad fact is, my Lords, that it is this very enforceability of the Convention, particularly by the European Court of Human Rights, that has long caused hostility towards it. Hostility from those who claim, and I believe claim wrongly, that the Convention and the Strasbourg Court are interfering with or even damaging life in the United Kingdom. Such arguments are not new, but I do not agree with them. The very strength of the Convention, my Lords, which is a living instrument, is that it allows individuals who are subject to unjustified interference in their rights and freedoms to hold those in power to account. I support the Strasbourg Court and its work to interpret the Convention in ways that maximise the rights and freedoms of individuals and that require governments to address any violation of those rights and freedoms. I support the rights and freedoms of all individuals, but a particular issue that is close to my heart is the issue of protecting the rights and freedoms of lesbian, gay, bisexual and transgender people. My Lords, my life has been changed for the better because of this Convention and the judgments from the Court. The importance of the Convention to LGBT people, indeed to any minority, cannot be overstated. It has positively transformed lives, particularly those often shunned by the mainstream. My Lords, turning to the judgments of the Court, the noble and learned Lord Etherton, who sadly cannot be in his place today, has asked me to specifically state that it was precisely because of the judgment ending the ban on gays serving in the military in the United Kingdom that we were able to end centuries of prejudice within the armed services that blighted so many lives. The Etherton Review and its recommendations, accepted by the previous government and this government, has begun to repair some of the damage. My Lords, I contend it is because of brave individuals, in this case supported by Stonewall, who had the courage to go through the arduous legal procedures, that we have been able to right these wrongs, but we can do more. Currently, because the UK has not signed up to Protocol 12, people in the United Kingdom have less protection from discrimination under the Convention than in many other European nations, and this is an unacceptable situation. And it would be highly appropriate if, on this important anniversary, the government would commit to extending the protection of Protocol 12 to all individuals in the United Kingdom. In conclusion, in these dark times, as we witness unimaginable human rights atrocities on a grand scale in parts of our world, we need more assurances and protections on human rights, not fewer. Complacency is the enemy of much and many, never more so in the field of human rights and civil liberties. Long may the European Convention on Human Rights speak to us, and especially to those, both here in the United Kingdom and across the world, who would diminish the human rights of others.
It's a pleasure to follow my noble
friend, Lord Cashman, and like him, I pay tribute to the very powerful opening of Lord Alton. My Lords, I've had the privilege in a long career at the bar of having taken 11 cases to the European Court of Human Rights and assisted on 2 others. And I can assure the noble Lord Lilly that the word paradise is not one that immediately comes to mind when addressing the 17 judges in that court. Lord, all the cases that I've been involved in have been trade union cases. Most of them concern the right to strike. Your Lordships may wonder how the right to strike could be protected by the European Convention. Well, Lords, it's simple. The European Court found that the right to strike was an inherent aspect of freedom of association and the right to form and to join a trade union for the protection of one's interests, which is spelt out in Article 11. And they derived it not by a process of a living instrument, but simply in accordance with the usual law on the interpretation of treaties, Article 31 of the Vienna Convention on the Law of Treaties. So, my Lords, the issue now on the right to strike is no longer whether it exists or not, or is protected by the Convention, but the legitimacy of national restrictions on it. Of course, in the years which have followed its establishment in the European Court, nearly a quarter of a century ago, many cases have been won, many cases have been lost. But recently there have been some very disturbing decisions in the European Court on the right to strike, upholding severe restrictions on the right to strike. I mention without discussion Barris and Turkey, Humpert and Germany, Kaya and Turkey, and Almaz and Turkey. Now, whatever the reasons for this line of authorities over the last couple of years, my instinct today is that, save in the most egregious cases, trade unions should avoid applications to the European Court in strike cases. But unlike the noble Lord Fawkes, the fact that I don't like a judgment or a line of judgments does not detract by one iota from my wholehearted support for the European Convention and the whole vital edifice of international law covering working life and beyond. As the noble Lord Alton has pointed out, this architecture was built on the corpses of tens of millions of people in the Second World War. It begins really before the United Nations Declaration with the International Labour Organization Declaration of Philadelphia in 1944, then the UN Declaration in 1948, ILO Convention 87 in 1949, Convention 98 in 1950, and the European Convention also in 1950. That post-war momentum carried on into the 60s with the European Charter on Social Rights in 1961, the 2 international covenants in 1966. Lords, these instruments are of course autonomous, but the jurisdiction each generates informs that of the others, so that there is a consistency in international human rights standards. Lords, neoliberalism may have ended the post-war consensus, and Hayek is now more influential than Keynes, but litigators, legislators and judges have a duty to uphold and deploy and be guided by these crucial instruments of civilization, and in particular the European Convention.
My Lords, it's a pleasure to follow Lord Hendy and to take part in the debate of Lord Alton, who gave a very masterful introduction, let me say. I served for 6 years on the Council of Europe, and for 2 years I was a chair of a small subcommittee for the enforcement of European Court of Human Rights judgments. It was one of my trivial pursuits questions: which country had failed the most applications to bring them into line, the answer, of course, I always got was, oh, Russia. No, that must be Turkey. Well, actually, it was Italy. So, you know, the court does a valuable job. And if I could just add to the number of dates we've had around, it was in 1966, Prime Minister Wilson, who accepted the jurisdiction of the court. So that's also worth putting into the record, because for 48 years we've accepted the jurisdiction of the court, and in good times and bad we have managed to survive. I also had 4 years on the Venice Commission, which is another bit of international cooperation attached to the attached to the Council of Europe. And for 2 years I was its vice chairman. I learned a lot about human rights because a lot of the Venice Commission references were concerned with one aspect or another of human rights. So I would also like the government to reaffirm its commitment. I'm sure it will, because that's the way I read these statements that have been made so far. But I'd also make two other observations. Where on earth is our Attorney General? We never see him. He's the top law officer. I very much respect the noble Baroness who is here to reply to the debate, but if ever there was a debate that needed the government's top lawyer, it is this one.
Yeah.
So I just make that point in passing, and I would also say I fully agree with a number of noble lords who've said that the judge is in the court, and indeed the Council of Europe itself has been busy with mission creep ever since it was set up. I recall when I went to Strasbourg as an elected MEP in 1979, the late John Silkin said to me, "Why do you want to join an outfit with no power?" I said to him, "John, put 435 politicians in a room and they'll soon find it." And if you look at the reforms of the European Union, for instance, the free movement and all the rest, it dates from that elected assembly. Can I make one final point? The government recently said that one of the problems we had was the I quote, the exploitation of the European Court of Human Rights by the human rights legal industry. I really think the government needs to look at the legal industry, and we need to find a way, because the judgment that's often referred to about chicken nuggets is a gross distortion of the work of the court, but it is something that maybe the government could address to try and see whether it's possible to issue some tighter guidance.
My Lords, the 75th anniversary of the European Convention on Human Rights would have merited a celebration, even if the noble Lord Alton, that tireless champion of human rights worldwide, had not given us an occasion today to do so in this chamber, and for that he deserves the utmost thanks. Three things about the Convention must surely not be forgotten. The first is that while it is the work of collective responsibility of many European parliamentarians and lawyers, a major input was made to it by the British contingent, many of them Conservative members, following the lead of Sir Winston Churchill, who played such an important role in the establishment and early years of the Council of Europe. And I'm saddened to see that this involvement seems now to be more a cause of shame than of pleasure. Second, the Convention was drawn up in the dark shadow, as many noble lords have said, of some of the worst crimes against humanity, including the Holocaust. Crimes perpetrated in our own continent by our own citizens. Its aim was to ensure protection for all our citizens against crimes committed often by their own governments. And thirdly, that when, at the end of the 1980s, the Cold War drew to a close, the Convention in its court was available to provide the countries of Central and Eastern Europe, including at the time the Russian Federation and Belarus, the freedoms and legal protection they had never previously enjoyed under Communist Party rule. Those are three achievements to be proud of and to treasure, however irritated some may feel at some of its court's rulings. I'm afraid I'm no lawyer, but my father was one, and he did teach me that hard cases make bad law. What is lamentable is that now, after these 75 years of achievement, some politicians and some parties in this country and some elsewhere in Europe are sharply critical of the Convention and its court. The main bone of contention is the impact on immigration cases, as all our governments struggle with the challenges of illegal migration and of asylum seekers. What is odd, and I find myself hard to justify, is that these challenges are often quantitatively far greater and far more acute in other European countries than our own, but we seem to be making quite a meal of it. Many critics here seem to be blissfully unaware of the extent to which the European Convention on Human Rights underpins fundamentally important parts of our constitutional structures and international agreements, most prominently the Good Friday Agreements in Northern Ireland and some of the most valuable parts of the Trade and Cooperation Agreement between the UK and the EU, in particular those dealing with justice and home affairs. These are clearly additional reasons for all, right across the political spectrum, to share the government's view that withdrawal cannot be contemplated. It would be good if more voices were raised to that effect. One final point. Our previous Prime Minister, the Right Honourable Rishi Sunak, got into the habit of calling the European Court of Human Rights a, quote, foreign court, unquote. That lamentable dog whistle nomenclature is not even accurate, since the court has had many admirable British judges down the years. But in any case, the terminology of speaking of a foreign court is all too typical of populist politicians of many of the main parties. It would be good if it could be taken out and buried on this 75th anniversary.
My Lords, I'd like to thank Lord Alton for arranging to have this debate and for all his encouragement to myself and many others in this House on human rights. I also would like to declare my interest as an ambassador and working with the Georgetown Institute for Women, Peace and Security on a number of these issues. And I would like to thank also those who are kind enough to send me briefings for today. My Lords, I'm pleased to speak on the 75th anniversary of the European Convention on Human Rights, a treaty that has safeguarded the dignity and freedom of over 700 million people since 1950. The United Kingdom was amongst the first to ratify in 1951 in the aftermath of World War II, when nations were united to ensure tyranny and injustice never prevailed again. My Lords, the Convention is more than a legal instrument, it is a moral compass. It enshrines fundamental freedoms, the rights to life, liberty, security and justice. It protects individuals from discrimination, torture and unlawful imprisonment, ensuring equal protection under the law. This is not an abstract document. It has evolved to meet modern challenges, my Lords, while upholding its core mission, defending human dignity. The impact is particularly evident in Northern Ireland, where the Good Friday Agreement enshrines the Convention, ensuring human rights is devolved legislation. This safeguard has reinforced peace and provided independent remedies where state actions have failed. Article 6, guaranteeing a fair trial, has prevented miscarriages of justice, my Lord. Landmark cases such as the exoneration of the Birmingham Six and the Guildford Four illustrate how the Convention has ratified grave wrongs and strengthened public trust in the judicial system. And amongst other cases, in JD and AV, the United Kingdom, in 2019, a survivor of domestic abuse faced eviction after government housing benefit reforms failed to consider the need for a protected panic room under a government-sponsored safety scheme. My Lords, the European Court ruled that this violated Article 14, which protects against discrimination, highlighting the Convention's role in ensuring policies do not disproportionately harm vulnerable women. And in VCL versus the United Kingdom in 2021, 2 Vietnamese children trafficked into forced labour were arrested and imprisoned, despite the authorities, my lords, knowing they were victims. The European Court found that the UK had breached Article 4, prohibition of slavery, and Article 6, right to a fair trial, emphasising that victims of trafficking should be protected, not prosecuted. For these reasons, we must commit to the Convention. Some have questioned, my lords, whether to withdraw from this treaty. I caution against such thoughts, as doing so would undermine decades of progress and expose vulnerable populations to renewed injustices. The Convention influence extends beyond national borders, guiding legislative reforms, human rights, education, justice in both post-conflict regions and modern societies. My lords, in Northern Ireland, adherence to the Convention has reduced sectarian violence and safeguarding minority rights. In courts, schools and communities, the Convention has ensured that human rights are not abstract ideals, but real enforceable protections. When governments are held to these high standards, society as a whole benefits through fairer trials, inclusive education and transparent government. My lords, let us renew our commitment to this vital treaty. The European Convention on Human Rights remains as relevant today as it was 75 years ago. It is a cornerstone of democracy, peace and justice, and I urge this House and all who value fairness and human dignity to stand united in defence, ensuring that its protection guide to its future, where every person's right is upheld.
My Lord, I too thank the noble Lord, Lord Alton, for initiating this debate and for his terrific speech in introducing it. Thank you. Perhaps I should declare an interest, my lords. I was privileged to be amongst Her Majesty's judges, sitting on the woolsack to hear the Queen's speech in 1997, and I well remember the quiver of excitement with which we greeted the announcement that her government intended to legislate to incorporate the Convention into UK law. This was not, or not just, because of the intellectual excitement that a new set of legal toys would give us to play with. It was because we were going to be given the tools to protect the fundamental rights of some of the most vulnerable people in the country. By then, it had become apparent that UK law did not always live up to the Convention standards. Others have, of course, mentioned the vital part that the UK played in setting up the Council of Tribunals and the Council of Europe and the Convention. But some have described this as the export theory of human rights. Foreigners needed them because they didn't have them. We didn't need them because we already did. So the European Convention was seen as embodying all the rights which UK people already enjoyed. Unfortunately, this wasn't always the case. The UK was losing an average of 18 cases a year in the European Court before the implementation of the Human Rights Act. Turning the Convention rights into UK law meant that we judges could speak the same language and use the same concepts. Our law was enormously enriched thereby, and far fewer cases went to Strasbourg as a result, and very few succeeded. And I should remind your lordships that it was the UK that invented the principle of constitutional interpretation that constitutional documents are a living tree, capable of development within its natural limits. And as others have reminded us, the Convention has done a great deal of good for the vulnerable and disadvantaged people, such as children, families, people with mental disorders and disabilities, victims of crime, and of people who suffer discrimination for no good reason but because of, for example, their sexuality, their ethnicity, or the colour of their skin. It was the Convention that insisted that children whose parents were not married to one another were entitled to the same family relationships as children whose parents were married. It was the Convention which insisted that if the state wished to remove children from their homes to protect them from abuse or neglect, the process had to be fair to everybody involved, both children and their families. It was the Convention that insisted that people with mental disorders and disabilities should not be deprived of their liberty without proper safeguards and the opportunity to challenge it. It was the Convention which insisted there should be no discrimination in the enjoyment of the Convention rights because of a person's sex, race, colour, or other characteristics such as sexuality or disability. The survivor of a same-sex relationship should have the same right to remain in the family home as did the survivor of an opposite-sex relationship. And this is the essential purpose of all human rights instruments, whether contained in international treaties like the Convention or in the written constitutions of almost every developed country in the world, to guard against the infringement of a person's fundamental rights simply because they belong to a group which the majority doesn't like. As I ventured to say in a judgment given in this House, when it was still the highest court in the land, democracy values everyone equally, even if the majority do not. Just to conclude, that was why it was especially shocking when this Parliament legislated to exclude a particular group of unpopular people from the protection of their human rights. Human rights are universal and should belong to everyone.
My Lords, I declare an interest as an advisor to DLA Piper on AI policy and regulation. And I start by thanking the Noble Lord Alton for not only securing this debate, but opening it with such an inspirational speech. And also to say, my Lords, what a huge pleasure it is to follow the noble and learned Baroness Lady Hale. I agree with every word she said. My Lords, the new Council of Europe Framework Convention on Artificial Intelligence is another living demonstration that the principles of the European Convention on Human Rights, after 75 years, are still highly relevant. The AI Framework Convention doesn't seek to replace the ECHR, but rather to extend its protections into the digital age. AI now permeates our daily lives, making decisions that affect our privacy, our liberty, and our dignity. These systems can perpetuate discrimination, erode privacy, and challenge fundamental freedoms in a way that demand new protections. Open for signature in September 2024, the AI Framework Convention is the first legally binding international instrument on AI, setting clear standards for risk assessment and impact management throughout the life cycle of AI systems. The Framework Convention's principles require transparency and oversight, ensuring that AI systems cannot operate as black boxes, making decisions that affect people's lives without accountability. They require parties to adopt specific measures for identifying, assessing, preventing, and mitigating risks posed by AI systems, and a specific human rights impact assessment has been developed. The Convention recognizes that in the age of AI, protecting human rights requires more than individual remedies. It demands accessible and effective remedies for human rights violations resulting from AI systems. Rather than merely reacting to harms after they occur, the framework mandates consideration of society's scale effects before AI systems are deployed. My Lords, I only wish, having heard what its director had to say on Tuesday, that our AI Security Institute had the same approach. The Framework Convention was achieved through unprecedented consultation, involving not just the 46 member states of the Council of Europe, but also observer states, civil society, academia, and industry representatives. Beyond European nations, it's attracted signatories including Israel, the United States, albeit under the previous administration, and most recently Japan and Canada in February this year. But, my Lords, a framework is only as good as its implementation, and this brings me to my central question to the government. What is your plan? The Ministry of Justice report to the Joint Committee on Human Rights on the government's response to human rights judgments 2023 to 24 said, once the treaty is ratified and brought into effect in the UK, existing laws and measures to safeguard human rights from the risks of AI will be enhanced. But, my lords, how will existing UK law be amended to align with the Framework Convention? What additional resources and powers will be given to our regulatory bodies? And what mechanisms will be put in place to monitor and assess the impact of AI systems on vulnerable groups? The Convention offers us tools to prevent such problems, but only if we implement it effectively. As we mark 75 years of the European Convention on Human Rights, we should remember that its enduring strength lies not just in its principles, but in how nations have given those principles practical effect through domestic law and institutions. The UK has long been a leader in both human rights and technological innovation. So, my lords, I urge the government to present a comprehensive implementation plan for the AI Framework Convention. Our response to this challenge will determine whether the digital age enhances or erodes our fundamental rights. And I don't need to emphasize the immense power of big tech currently. We need to see this at a time when we are rising to meet new challenges with the same vision and commitment that created the European Convention on Human Rights 75 years ago.
My lords, this is a timely debate, and I'm grateful to the noble Lord Alton, for securing it. I declare an interest as a member of Justice and indeed a past member of its Council for some years. My lords, the European Convention of Human Rights is a significant document. It embodies important values, but equally important and legitimate criticisms can be made of the jurisprudence which the Court has generated. What the United Kingdom should do now and in the future has become a legitimate question. The concerns which I shall express in this speech do not go to the Convention itself, but to its misapplication by the courts in the implications for our Constitution. The Strasbourg Court has the task of defining Convention rights in practice. In performing that task, the Court has treated the Convention as a living instrument. That is of itself not a term in the treaty. It has used that to alter the scope of rights, to give effect to changes in social attitudes, matters which in the United Kingdom are generally best left to Parliament. Let me give some examples. In Scopola and Italy, number 3, the Strasbourg Court declared the statute which barred serving prisoners from voting at elections to be incompatible with the Convention. The suggestion, I suggest, that the electoral franchise is not a matter in which the representatives of the general body of citizens have any say seems startling. So too, the recent extraordinary climate change decision in Klima Seniorinen against Switzerland, which the Swiss Parliament has not surprisingly voted to ignore. Articles 8 and 10 have been used to gag the press. In Al Skeini, the House of Lords excluded claims against the army because the victims had not been within the jurisdiction of the United Kingdom. Strasbourg overturned that decision. But I suggest the parties to the Convention never intended it should apply to warlike operations carried out by member states in foreign jurisdictions. Strasbourg has expanded the range of the Convention and interpreted it in ways well beyond anything envisaged when it was made. Issues of public policy involve choices between competing considerations. That is the essence of government and legislation. It is what our Parliament is there to decide. But where do we go? We are on the horns of a dilemma. The constitutional effects of leaving the Convention would be serious. The United Kingdom would likely be expelled from the Council of Europe. That's not something which I seek to endorse. Withdrawal would put the United Kingdom in breach of the Good Friday Agreement, written into the Northern Ireland Act, 1998. None of us would want that.
The Convention is also baked into the United Kingdom-EU Trade and Cooperation Agreement, the TCA. For the United Kingdom to denounce the ECHR would be ground for the EU to terminate the part of the TCA on law enforcement and judicial cooperation in criminal matters. That would be a serious problem for us all. But something must be done. At the minimum, I suggest, we must look again at the Human Rights Act, and it should be amended to mitigate the constitutional problems to which it gives rise. But that is for another speech.
My Lords, I too extend my congratulations to Lord Oulton for his truly magnificent opening. I declare an interest since I was a government lawyer for 34 years, and the ECHR often presented legal obstacles for the government of the day, which I was advising. So I understand, therefore, why some would like to withdraw from the ECHR. One of the reasons often given is Article 3, which, as interpreted by Strasbourg, prevents the UK from sending failed asylum seekers and others back to their countries of origin where there are grounds for believing there's a risk they will be ill-treated, however compelling the public interest reasons for removing them. This is the non-refoulement principle. My Lords, I don't see how withdrawing from the ECHR would be the answer. Politically, it would cause difficulties for the Belfast Agreement, which assumes continued ECHR membership, and would risk ending, as we've heard, criminal justice cooperation with the EU. Legally, in addition to many other international treaties which replicate the effect of Article 3, we are bound by customary international law, arising from the constant and uniform practice of states, including the United Kingdom, of complying with the non-refoulement principle, at least where the risk of severe ill-treatment is concerned. Leaving the ECHR so as to try and get around Article 3 would raise questions about our future compliance with customary international law. My Lords, there's no doubt that the Strasbourg Court has used the living instrument doctrine in ways with which some contracting states may now disagree. The line of case law, beginning with Alskany, which was referred to, on the extraterritorial effect of the Convention, is a good example. However, the answer to any perceived undesirable effects of the living instrument doctrine is not to leave the Convention, but to reform it by bringing together contracting states to instigate reform, as was done recently with Protocol 15 on subsidiarity. For example, where a specific piece of international law governs an issue, then perhaps the more general ECHR either shouldn't apply or the Strasbourg Court should be required to take account of it, which is a recognised principle of international law. This could be the case in respect of the Geneva Conventions on Armed Conflict, the Paris Agreement on Climate Change, and possibly even the Refugee Convention, where, unlike under Article 3 as interpreted by Strasbourg, exceptions, narrow exceptions, on grounds of security can apply in certain circumstances. In addition, we must ensure our rich human rights heritage is preserved for future generations by a programme of civic and constitutional education on human rights, and the balance to be struck between such rights and individual responsibilities as recommended by Sir Peter Gross's independent review of the Human Rights Act in 2021. In conclusion, as we look at the increasing number of human rights abuses taking place around the world, which are totally blind to the rule of law, the scales are now weighted strongly in favour of continued membership of the ECHR, while seeking any reforms which will bring the Convention more in line with what the contracting states may seek now in 2025.
My Lords, I'm a member of the Parliamentary Assembly of the Council of Europe, and I'm glad to begin my remarks by stating that bald fact. I do want to say to those who've spoken, Lord Oulton, his speech, and Lady Hale, if there were tick boxes I would put a tick in and then sit down because I don't want to say any more than that. But in a debate recently in Strasbourg, entitled rather quaintly, I thought, Multiperspectivity in the field of journalism, which was all about how journalists can see the same facts and report two entirely different stories, I feel I want to apply it now to the House of Lords, that people see the same facts and draw entirely different narratives from them. We've heard, and let me say that I've always felt a bit fragile in your Lordship's House, since I have no political experience and certainly no legal experience. So consequently, I listen to the debate in order to hear where things stand. And multi-perspectivity has marked this debate. From the political sphere, all I can say to the noble Lord Lilly is that it's such a relief to me that two rows behind you sits the Earl of Dundee, whose remarks on the Council of Europe and indeed about the Convention are so positive, and he has served with such a distinction in Europe. He's widely honoured for the contribution he's made to its affairs. So there's multi-perspectivity straight in my eye as I look across the chamber. Similarly, I think, in terms of the legal arguments, it's always been my contention. We had all those debates about immigration during the tenure of the last government, and it was always difficult for me as a non-lawyer to hear distinguished lawyers on each side of the argument, except that from the government side, and Lord Murray is here, he was obliged by convention, of course, not to disclose what legal advice the government was receiving, but he did a doughty job at the dispatch box. But for all of that, for those of us who stand listening, it can be very difficult to know how to make the distinctions we need to make. Now, I've just joined the Constitution Committee, so the future of Britain is under threat. But I do just want to say that the rule of law is what we've set ourselves as our first project. I had breakfast last week at the Supreme Court. I mean, never have I been surrounded by so many stars in the galaxy as I was then. But I did make the point that the United Nations Charter, the Universal Declaration of Human Rights, and the European Convention all have as Article 6 access to a fair trial. And I started my remarks on that occasion by stipulating that the architecture of my entire life has been built on the fact that when I was 5.5 years of age, a letter from my father's solicitor to my mother indicated that because she was the guilty party in their relationship, she should leave his client's, my father's, house within 1 week and take her children with her. My mother couldn't defend herself against that because she didn't have 2 pennies to put together to get the legal counsel or support, and in any case the law was different then. And out of that little exchange in the Supreme Court has come a magnificent response from one of the justices who specializes in access to justice, who brought out in 2016 a report just about how to deal with the fact that where we are with people not having access to justice and wanting to have its recommendations implemented all these years later. I look forward to the future, all those voices to listen to, all those things, cases to weigh up. But I have to say, the politicians should try a little harder, and the lawyers should try a little harder to realize that not everybody is one of them.
Well done. Well, my Lord, it's a pleasure to follow Noble Lord. I wish to say a few words about the relationship between judicial protection of human rights and the rule of law, and in particular about the way in which Parliament should respond to declarations of incompatibility in cases of constitutional importance. In his classic work on the rule of law, Lord Bingham identified important distinctions between what one might call the primary articles, which confer an unqualified right to a defined outcome, not to be tortured, a fair trial, etc., and articles such as Article 8. Article 8 guarantees not a defined outcome, but instead respect for private and family life, and is subject to an important qualification, which Lord Bingham calls, quotes, a community exception, a recognition that the rights of the individual may properly be restricted in the interests of the community at large, if certain conditions are satisfied, close quotes. When judges are asked to give effect to and protect qualified rights, such as those conferred by Article 8, they are being asked to make an evaluation of the relevant competing considerations, which necessarily involves moral and political analysis. The danger is obvious. It is highlighted by a different chapter in Lord Bingham's book, entitled Law Not Discretion. There, he wrote, questions of legal right and liability should ordinarily be resolved by application of the law and not the exercise of discretion. The balance is held, or should be held, by the fundamental constitutional principle that Parliament is sovereign. The Human Rights Act was carefully drafted in a way that reflects this. Judges are not able to strike down acts of Parliament. Senior judges can make declarations of incompatibility. In most such cases, Parliament properly reacts by amending the legislation in question in accordance with the Court's judgment. It is not obliged to do so and has not always done so. As a matter of procedure, following the making of a declaration of incompatibility, Section 10 of the Act permits the government to amend legislation by a remedial order, which will normally go through on the nod. The Act states, importantly, that this form of fast-track amendment is only permissible where the Minister considers that there are, quotes, compelling reasons for proceeding under this section. I turn then to a current matter in which the government proposes to make a remedial order of this nature. In short summary, the Supreme Court held a few years ago in the Adams case that Mr. Adams's internment in the 70s had been unlawful because the relevant certificate had been signed by the wrong minister. This rather technical point, taken over 40 years late, opened an unappealing vista of many thousands of claims for compensation. A provision was introduced into the Legacy Act with the support of all major parties, which, put colloquially, neutralised the Adams decision. In 2024, a single judge of the Northern Ireland High Court made a declaration that this provision was incompatible with the claimant's rights. That decision may have been right, it may well have been wrong. It has been the subject of penetrating, some might think lethal criticism in a policy exchange paper written by Professor Eakins and Stephen Laws. The noble and learned Lord Hope did provide an illuminating preface in which he supported the views there expressed and explained precisely why it was inappropriate to respond to the declaration of incompatibility by making a remedial order pursuant to Section 10. The government appealed the Northern Ireland decision. It is beyond question that that appeal raised issues of fundamental constitutional importance. In summer 2024, the new government withdrew the appeal. The reasons for that decision are obscure. Now it is proposed that a remedial order be made whose effect will be to remove the neutralising provision. This can only, as I've explained, this can only lawfully be done if there is a compelling reason to use the Section 10 fast-track procedure. There is plainly, my lords, no such compelling reason. On the contrary, there are compelling reasons why the primary legislation should be amended in the usual way, which will give Parliament the opportunity to consider the matter carefully, as clearly it needs to happen. If the noble lady, the Minister, were able to update the House as to the government's plans in this respect, that would be of great interest.
My Lords, I join others in warmly commending the noble Lord Alton for securing this debate and for his excellent speech, which has set off a very valuable debate. Noble Lord Alton is a true Liberal, whatever his current location. I think it is unusual for a member of the House of Lords to have the honour of chairing the Joint Committee on Human Rights, but it is a tribute to him and an honour for this House that he does so. I should just record my interest, which is in the register as a Vice President, to my noble friend, I hope and call her that, Baroness Kennedy of the organisation Justice. Now, we've heard voices today calling for the UK to leave the European Convention on Human Rights, or at least seek to change it or the Human Rights Act. But I ask if we really want our country to be bracketed with outlaws like Russia, Belarus, and indeed Hungary in ignoring and rubbishing human rights. That would be a regressive and deplorable step. I agree with a comment by Amnesty, and I don't always agree with Amnesty, The conduct of the current Russian government should be a reminder to us all of our good fortune to live in a country with respect for the rule of law and which, in the main, complies with the rulings of independent courts. The UK leaving the Convention would be exactly what Putin wants. The Convention and court system that it is attached to forms a core part of the framework of the long-standing international alliance of states gathered together in the Council of Europe, dedicated to the pursuit of the common goals of human rights, democracy and the rule of law. And I commend noble lords, including my noble friend Baroness Brinton, who take part in the Parliamentary Assembly of the Council of Europe, which I have never had the honour to do. I would point out to the noble Lord Lilly, and I'm grateful he's still in this place, I know he has other commitments, that Commonwealth countries are not in the ECHR system because they are not, except Malta, Cyprus and the UK, located in Europe.
For replying to that point, the point is that they don't rely on an international agreement to provide very good human rights to their constituents. They are citizens. Why should we be different?
I think that might set up another mini debate, and I'm going to not be tempted to go down that road. For a major power such as ourselves, a founding member of this European system, to leave the Convention, and thus the Council of Europe has been a point made by several noble lords, would sow division and confusion amongst liberal states just when we need solidarity. It would demonstrate that the protection of individual rights against the excesses of state power is an unimportant and futile endeavour. Indeed, our membership, along with all the other liberal democracies in Europe, of the Council and its Convention, is part of the system of regional security that is so vital now. It creates the preconditions for peace through the promotion of democracy, the rule of law and human rights, and helps inoculate people and governments against the pernicious propaganda coming out of Moscow and elsewhere. The ECHR is not some remote foreign product to be resisted as an imposition. That point was made by one noble lord, and I do apologise, I've forgotten who. And we should in fact celebrate that the UK has played a pivotal role in not only creating but shaping the ECHR. And I did note that several of the lawyers involved, like the noble Lord Alton of Liverpool, seem to come from Merseyside. So that must be a fertile source of human rights inspiration. Our judges continue to contribute to the future of the Convention system and the wider protection of human rights. I do hope that the government will highlight the UK's role and work to combat negative rhetoric, misrepresentations and misunderstandings. The UK's commitment to the ECHR and more widely to the rule of law also helps not only boost our international reputation, but also our attractiveness as a place to do business by emphasising that both individual and business rights are protected. Our commitment to the international rule of law underpins our global economic competitiveness and attractiveness as a destination for investment that the government is rightly emphasising at the present time. And thus it's a part of the government's growth mission. Now, I was intrigued to read an article in the Times this week by the noble Lord Hague of Richmond. He is not in his place, but as this article was published, I feel able to comment on it without, I hope, being discourteous. The article was headlined, "I'm no fan, but," and a but like that always puts one on notice. And his declaration that, quote, Trump's effect may be positive in promoting a startling realignment of ideas was a jolt, because I confess I see nothing positive coming from President Trump. And indeed, one of the positive nudges that the noble Lord Hague felt was a result of President Trump was that the ECHR should be rewritten. He didn't say how, but if he only meant in the way Lord Carter, the noble Lord Carter referred to, that might be sensible. And I think we're all open to any useful reforms. But where the noble Lord Hague then confused me was that he stressed These actions of Trump are a reminder that an effective democratic state is part of a moral order in which its policies should be anchored, that its reach and respect in the world rely on being able to distinguish right from wrong, that the abuse of great power brings resistance and rejection. I thoroughly agree with the Noble Lord in those remarks. So my contention would be that far from rewriting the ECHR as a reaction to President Trump, we should treasure it all the more as guarding against the kind of developments that we are sadly seeing in the United States. The Human Rights Act brought rights home, as has been said. It was one of the products of the talks on political and constitutional reform 30 years ago between Labour and the Liberal Democrats, known as the Cook-McLennan talks, after Robin Cook and Robert McLennan. And I'm very proud of that and other products. And I was delighted to hear the noble and learned Lady Baroness Hale stress the value of the Human Rights Act. Now, we've heard that applications to Strasbourg have been on a general downward trend over the last 10 years. And the Human Rights Act has contributed to that, because a lot of those cases have not gone to Strasbourg because they've been settled domestically. In 2024, there were only 3 cases against the UK heard by the court, and I believe only one found a violation. The victor was the Daily Mail on a freedom of expression case. And there were no interim measures, injunctions, issued against the UK last year. Now, this is a testament to the strength of our national system of human rights protections. And one of the reasons for this harmonious state of affairs is that a productive dialogue has taken place between the Strasbourg and UK courts, such as to deal with any tensions or disagreements. And this was particularly confirmed in the remarks of the noble and learned Lord Neuberger, as well as Lady Hale. I've lost my way, sorry. Now, for some people, no Bill of Rights, whether the European Convention or any other, will be acceptable in the UK system of a political constitution and parliamentary sovereignty. These arguments are always presented as concerns about democracy and democratic accountability. However, they almost always end in arguments for centralising power in the executive. And a lot of the point of human rights challenges is to call the executive to account. References to the court going too far as a reason to leave the convention system more generally are almost always based in choosing to emphasise the occasional controversial case where the speaker disagrees of the outcome. Yeah. So I would just like to draw towards an end in emphasising, as the noble Lord Hannay did, that any upset to our relationship with the ECHR would affect the Belfast Good Friday Agreement, which is absolutely crucial instrument. And under that agreement, the UK government committed to the incorporation of the convention into Northern Irish law. Proposals to legislate for the continued application of the Convention into Northern Irish law while withdrawing the UK as a whole from the Convention are fundamentally flawed, and there's no practical way of legislating for partial implementation. In addition, the UK is obliged under the Windsor framework, following our withdrawal from the EU, to observe a non-diminution of rights as set out in the Belfast Good Friday Agreement. And there are also, as also been said, I think, by the noble Lord Hannay, there are commitments in the Trade and Cooperation Agreement to our continued adhesion to the ECHR. And any damage to our human rights observance could also imperil the renewal, crucial to both business and law enforcement cooperation with the EU, of our Data Adequacy Agreement. For all these reasons, we should not imperil our positive engagement with the European Convention in court, but instead celebrate our great achievement and good fortune in creating it and sustaining it for 75 years.
My Lords, it's a pleasure to speak for these benches in this debate, procured by the noble Lord Alton, whose work in the field of human rights needs no introduction. In fact, I remember when I grew up in Liverpool. I don't know whether in Baroness Ludford's eyes that now makes me a human rights lawyer. Lord Alton was campaigning for the rights of Jews and Christians in the USSR to practice their religion, and therefore I'm especially grateful to him for today's debate, in which we've had the privilege of hearing a number of very fine speeches, some of which have relied on the undoubted human right to push the boundaries of the advisory time limits. Of course, today's debate is not about human rights per se. It's about the European Convention on Human Rights, and the two are not the same. To make the obvious point, we had human rights in this country before we signed the European Convention on Human Rights, and many countries in this world which aren't signatories to that convention still have and champion human rights. But the European Convention on Human Rights has a long history, and we played a central role in its inception. We were one of the original signatories. We also, as your lordships have heard, helped to draft it. And in 1951, two important things happened in the field of human rights in this country. First, we as a state signed the European Convention on Human Rights, and second, the noble Lord, Lord Alton, was born. We were, in fact, one of the first states to ratify the convention, and since 1965 we have also accepted the jurisdiction of the Strasbourg Court, the European Court of Human Rights. And I am proud of our role in building the more just future for Europe from which we all benefit today. And I've mentioned the dates because they're important for context and background. When the ECHR was being drafted, Europe was still recovering from the horrors and destruction of the Second World War. It was only 2 years after the Nuremberg trials that in 1948 the United Nations promulgated its Universal Declaration of Human Rights, from which the ECHR's founding principles flowed. And I therefore suggest that it is appropriate that on the Annunciator right now we have both the anniversary of the ECHR and also the Holocaust Memorial Bill. Now, I want to move obviously from the history to the ECHR today. I agree with a lot of what my noble friend Lord Lilly, who explained to me why he had to leave, said about the history. There is a pretense sometimes about the history. It isn't all as people say it was. But let me move to today's position. There can be no doubt, I would suggest, as the noble and learned Lord Newburgh of Abbotsbury explained, that the ECHR has led to legal advances. It has enabled judges to make innovative and expansive rulings in the fields of, to pick just a few topics, sexual equality, privacy, and personal autonomy. But we also have to accept that the approach of the ECHR is to entrust such lawmaking to a court, the Strasbourg Court, which is accountable to no one. And while that might be good if you prefer its decisions to those which governments might otherwise have made, this creates an obvious conflict between parliamentary democracy and an unelected court, especially when that court has gone on to adopt what I would suggest to be a very expansive interpretation of the convention, as my noble friend Lord Murray of Blidworth explained. Those conflicts range far and wide and well beyond the scope of this speech, but you can get a sense of the issue from an analysis of 25 leading cases from that court, which have been analysed by Professor Richard Eakins and others in an illuminating paper published by Policy Exchange. And it's important to appreciate that that is not a bug, it's a feature. The lack of accountability of the European Court of Human Rights was precisely what made it appealing to those who set it up in the aftermath of fascism and Nazism. They saw the court as providing a check on elected governments which might otherwise abuse their power. And I understand that desire. I share it to an extent, but there are limits. And I wonder whether last year's decision of the court in the Swiss climate change case has showed that we have reached those limits and perhaps gone beyond them. And let me explain why. In 2021, the Swiss electorate rejected in a referendum an act of the Swiss Parliament which called for a 30% reduction in emissions from 1990 levels by 2030. That act, rejected by the electorate was then replaced by an act which provided for a staged reduction by 2050. That more moderate act was approved by the Swiss people in a referendum. There's nothing in the convention about public health. There's certainly no mention of climate change. But that didn't stand in the way of the Strasbourg Court, which held that Article 8 right to private and family life required governments to take what it called effective measures to combat climate change, and those measures had to be those consistent with the views of the UN Governmental Panel on Climate Change. And that, of course, is the answer to the oft-made challenge, I think made today first by the noble Lady Baroness Kennedy of the Shores: which rights don't you like? I like all of them as drafted, not all of them as interpreted expansively. And so the court held, in that case, that Swiss law was inconsistent with the convention. What about the fact that the Swiss people and their parliament had twice had a say in referenda? The court said this: democracy cannot be reduced to the will of the majority of the electorate and elected representatives in disregard of the requirements of the rule of law. Now, I will give way to no one when it comes to the rule of law. But the rule of law does not require judges to have a roving commission over whole areas of contested and contestable national public policy in complete disregard of the expressed wishes of both Parliament and the people. And as our judges on the court have been mentioned, I should add that the UK judge on the court wrote a powerful and principled dissent to this decision, which repays careful reading. Now, of course, the question is not whether the decision is right or wrong on the facts. It's not about whether climate change is real, it is, or whether we should take it seriously, we should. It's about whether and how we make laws on such issues in a democracy. And as my noble friend Lord Sandhurst pointed out, in cases where you have contested issues of public policy and you have to balance a lot of factors, the effect of the court's decision is that these arrangements are arrogated only to the court. Not only now must the Swiss change their statute, but it seems that they must also take steps to ensure that that changed statute is not itself rejected in a referendum by voters. To pick up Noble Lady Baroness Ludford's point, this does not centralise power in the executive. It centralises power in a court, contrary to the expressed wishes, in that case, of both the Parliament and the people. Nor, I suggest, is it consistent with the rule of law. One of the principles of the rule of law is that it must be stable, clear, publicly accessible, and not retrospective. And the decision of the Strasbourg Court in that case is none of those things. As the UK judge said in his dissent was of a more fundamental nature. It goes to the very heart of the role of the court within the convention system. And he ended with this: I fear that in this judgment, the majority has gone beyond what it is legitimate and permissible for this court to do, and unfortunately in doing so, may well have achieved exactly the opposite effect to what was intended. Those of us who have concerns about the approach of the Strasbourg Court have those concerns because we believe in human rights, not because we have concerns about human rights. Our party has made a powerful and lasting contribution to law and justice in Europe and beyond. We remain committed to those values of law and justice, but we need to recognise that the Europe that gave birth to the Convention is a Europe of the past, and we do need new international or improved agreements, as Lord Carter identified, that are fit for the present challenges we face and also appropriate for those of the future. Now, I know over the past couple of years in this House we had long and heated debates on immigration policy. The fact is that over the past years, our ability to manage immigration has been hindered by interpretations of international laws, including the ECHR, which are a long way from the intentions of the states when they signed up to those treaties and conventions. And I may not be the only one who's had a little wry smile over the past months of hearing echoes of what I used to say from that dispatch box repeated in press summaries from Number 10. Things look different when you're in government, as I think the party opposite is now finding. And I accept that press reporting of judgments is often exaggerated and sometimes plain wrong. But those who deny that there is a problem at all are also wrong. And that's why we, in the other place, tabled an amendment to the Border Security, Asylum and Immigration Bill that would disapply the Human Rights Act from immigration matters. It is ultimately important that Parliament and ministers have effective control over our borders. But let me end on a note where we will all agree. In a world where the threat of totalitarianism remains, we mustn't disavow our moral duty to promote justice. And that principle stand is entirely compatible with work, perhaps across the House, to ensure that our international agreements remain appropriate for the challenges of today and the future. And so I again congratulate the Noble Lord Alton for initiating this debate and wish him many more years of fighting in good health for the causes close to his heart, both in this House and also outside it.
My Lords, I would just like to thank Lord Wolfson for that speech. It's good to see him. I am very sorry to have learned of the death of his father recently, and may his memory be a blessing to you. I enjoyed his speech very much, didn't agree with some of it, but he's always entertaining and speaks with passion. I would just gently say on the issue of immigration, about which I've argued with very many ministers over the 14 years we've enjoyed our time in opposition, that the last government did completely lose control of the system. They had an expensive distraction with Rwanda. There was no coordination across Whitehall, minimal engagement with foreign governments on the topic. I do wonder what some of the ministers were doing while they were making speeches about immigration, but then doing precious little to actually deal with the problem. What he says about ECHR may or may not be right, but there were so many other things that could and should have been getting done that weren't, that we have plenty to do before we get to ECHR reform when it comes to tackling immigration. Having said all that, I would just like to thank Lord Alton. He has inspired many people inside and outside of this chamber over very many years. He set out his argument, I thought, most convincingly, and I thank him for securing this debate. And I'm going to begin by completely reinforcing Lord Lilly's assertion that we always start with history. Yes, we often do. Not as far back as the Bishop of St Albans with the Ten Commandments, but I will begin with March 1951, when the UK became the first country to ratify the European Convention of Human Rights, or the ECHR. Signed in Rome on the 4th of November 1950, it came into force in the United Kingdom in 1953. And while some commentators would have us believe that the ECHR is something that was imposed on us unwillingly by our neighbours, this is not the case. In response to the horrors of the Second World War to engulf the world in a generation, Winston Churchill was a leading proponent of a Council of Europe. That made this convention their first order of business. Indeed, I know that recently the Lord Speaker and many of my noble colleagues commemorated the historic moment when the treaty that led to the creation of the Council of Europe was signed at St James's Palace in 1949. And I should like to recognise the contribution made by members of both houses who serve on the delegation to the Parliamentary Assembly of the Council of Europe under the able chairmanship of the Noble Lord Tuig. Furthermore, a British Conservative MP and lawyer, David Maxwell Fyfe, played a leading role in drafting the convention. Pioneering Labour Foreign Secretary Ernest Bevin was active in shaping the convention, and the first president of the European Court of Human Rights was British too, Lord Arnold McNair. Indeed, the government is proud of Britain's role in the formation of the European Convention on Human Rights and of all that it has made possible for our individual rights and freedoms in the decades since. That spans everything from forming an important pillar of the devolution settlements to underpinning guarantees in the Belfast Good Friday Agreement, to supporting the safety and security of British citizens by facilitating cross-border law enforcement and judicial cooperation in the Trade and Cooperation Agreement. Yet there's so much of what the ECHR does for us goes unsung, precisely because so much of it sounds so abstract. So today, noble lords have shone a light on some of the ways it's made a difference in the lives of people across our country for decades, by reminding us of some of those stories. Baroness Chakrabarti explained movingly about the impact of the Convention on victims of sexual violence. Baroness Kennedy, Baroness Gowdy, Lord Sandhurst and Baroness Ludford reminded us how central the ECHR is to stability in Northern Ireland. Lord Rooke spoke of freedom of religion or belief. Lord Cashman spoke of how the ECHR has literally changed his life. Lord Hendy reminded us of the Convention on Trade Union, the impact of the Convention on trade union activity. We also can consider the abolition of corporal punishment in the UK. In 1982, it was an ECHR ruling that put an end to school children being beaten against their parents' wishes and paved the way for the eventual abolition of corporal punishment in all state and private schools in the UK. The status of homosexuality in Northern Ireland, male homosexual acts were a crime in Northern Ireland until 1982, yet a human rights case brought to the ECHR by a gay rights activist from Belfast argued that the criminal law in Northern Ireland amounted to an unjustified interference with his right to respect for his private life. It was rightly decriminalised. Then there's the duty on states to protect the right to life. The families of the 97 football fans who lost their lives in the 1989 Hillsborough disaster relied on that to obtain a new inquest that concluded that the fans were unlawfully killed as they campaigned for the truth. Lifting the ban on LGBT people joining the military, following a landmark case in 2000 brought by 2 British servicemen who'd been dismissed from the army simply for being gay. The law changed, allowing members of the armed forces to be open about their sexuality. Then there's the protection of religious belief in the workplace. When an employee of British Airways who wore a small cross around her neck as a sign of her religious faith, she was suspended from work without pay because the cross violated its uniform policy. Yet in 2013, the ECHR ruled that this was an unreasonable interference with this woman's right to freedom of religion, leading to a change in relevant standards in the UK. Indeed, the ECHR continues to provide protections to the rights of British citizens at home and abroad. Only last month, the court ruled that the Cypriot authorities had failed a British woman who'd alleged that she'd suffered horrific sexual violence in Cyprus in 2019, finding there'd been lack of effective investigation and a violation of her right to respect for private and family life. These stories remind us just a few of the ways that our country and our people have benefited from the protections of the European Court of Human Rights over the years. And as well as applying the law consistently and working in partnership with others well beyond our continent as well, it's important that we tell them. Sadly, there are some who seek to paint a picture of the UK constantly under attack by the European Court of Human Rights, and I'm not saying that that's what the noble lord opposite did today. I think his comments were considered. But it's worth noting too that the UK has one of the lowest rates of applications to the court per million inhabitants, as Lord Thomas said, and that last year there was only one adverse judgment given, finding one violation against the UK. The Human Rights Act, which a Labour government put in place, gives effect to the ECHR in UK law, and it was wonderful to hear Baroness Hale's recollection of the Queen's speech making this announcement. It's an important part of our constitutional arrangements and fundamental to human rights protections in the UK. Of course, no organisation is perfect. Neither the ECHR nor the European Court of Human Rights are static or frozen in time. Rather, the ECHR is a living instrument that evolves in response to emerging challenges in challenging times. The European Court of Human Rights has shown itself to be open to change. Indeed, during the UK presidency in 2012, Council of Europe member states adopted a substantial package of reform measures, and only last year the European Court of Human Rights introduced more fairness and accountability into their approach to interim measures following consultation with member states as well. And there is one accepted principle of dialogue between national courts and the European Court of Human Rights, through which the UK continues to influence the direction and impact of the ECHR. Our respect for the rule of law, both domestically and internationally, is profound, as we're demonstrating through our actions. And that is more important than ever, at a time when we've been dealt a stark reminder of what is at stake for all of us now. The Earl of Dundee asked about development and education, and I can confirm our commitment and support along the lines of his comments, and also about partnerships and higher education, and it was a helpful question that he put. The Lord Clement Jones invited me to talk about AI regulation, and he will forgive me if I don't. But I'm sure that a DSIT minister will be along very shortly and happy to take his questions on that. But there are things that we all need for a good life, and they are security, prosperity, equality, human rights, and the rule of law. And I'm afraid I differ with Lord Foulkes, but I agree with many lords, noble lords, including Lord Griffiths, Baroness Ludford, Lord Carter, Lord Balfe, Lord Hannay, Lord Neuberger. And my lords, as my right honourable friend, the Prime Minister, has said, and as Lord Jay said we should, this government is firmly committed to the European Convention on Human Rights, and we will never leave it. As my right honourable friend, the Foreign Secretary, has said, quoting former Labour Foreign Secretary Robin Cook, it is self-evident that a world where every individual's rights are respected is a world which will be more peaceful, and where Britain will be more prosperous and more secure. As we reset and deepen our relationships with friends across Europe and beyond to help us face the challenges and opportunities of our times in the 75th year of the European Convention on Human Rights, we welcome this chance to reflect on all that we've achieved and to look forward to what needs to come next. We're a government with a progressive, realistic outlook, meeting the world as it is, working towards how we want it to be in the months and years ahead. So we look forward to the celebrations in Strasbourg in November. Thank you.
My Lords, the noble Lord Wolfson referred to his childhood when I was his family's constituency member of Parliament in Liverpool. And the noble Baroness Lady Chapman, in replying to the debate, referred to something which deeply affected me during my time, of course, as a Member of Parliament. I never expected to have to visit families whose children had died at a football match, as they had done at Hillsborough. So I have been enormously grateful to the effect that the European Convention has had in helping to shift the law, and indeed to the government for the commitment that it gave at the general election to enact the so-called Hillsborough Law. It's an issue which the Joint Committee on Human Rights has engaged with, and indeed we recently published correspondence between the committee and the government on the duty of candour. It's a good example, I think, of how events which take place here in our own jurisdiction but have implications elsewhere, how they can be affected jurisdiction to jurisdiction, person to person. Some very kind words have been said by noble lords in making their remarks today, not least about my longevity. I'm grateful to the noble Lord Wolfson, but also to the noble Lord Rooke, who said he hoped one day to grow up, he said, to be like me. I don't wish that on him, or indeed on anybody else, but I feel a bit like Methuselah at the end of today's debate. My lords, the noble Lord Griffiths of Bury Port, for whom I have great fondness and admiration, made a very good speech about why we should keep our feet firmly on the ground and never lose sight of the human impact of the decisions that we make. He told us that he'd been to the Supreme Court and he felt as though he'd been surrounded by stars in the galaxy. Well, you don't have to go all the way to the Supreme Court to feel as though you're surrounded by stars in the galaxy, and I would like to pay particular tribute to some of the very distinguished and celebrated peers who have spoken in today's debate. These have been wise voices, and my lords, I think we would be foolish not to study carefully what has been said to us from all sides of the argument. This is a debate that's been worthy of the anniversary, but also worthy, I think, of your lordship's house. Reference, and I'm not going to obviously try to respond to all the speeches, I'll be brief, but reference has been made to Article 3. And my noble friend Lord Carter was right, that of course even if you didn't have the ECHR, the 1951 Convention on the treatment of refugees would still be in place. We have also been cautioned by the Noble Lord Bath, by my noble friend Baroness Ludford and others, about the dangers of building a whole argument on one or two cases, and the so-called chicken nuggets case has been referred to. Go away and read Joshua Rosenberg's article this week, where he reminds us that a lower tier tribunal got it wrong and an upper tier tribunal got it right, and that this will not, he says, prevent the deportation of someone who may be here illegally and therefore should not be resident in the United Kingdom. So let's not build a case for the total deconstruction on cases like that. It was again a noble lord who reminded us, I think it was my noble friend Lord Hannay, who said that hard cases make bad law. My lords, when you start to unravel and disrupt, it carries consequences. But that isn't an argument against reform, and I take the arguments that have been made from particularly Conservative benches today, that this isn't a static instrument, it's not incapable of reform, and things like the Swiss case are things for the Joint Committee on Human Rights to go back and look at and to take evidence over. And I hope that the noble Lord Murray and I will agree about that and find ways for us to look at that kind of judgment, and whether or not we're going too far in some circumstances. But, my lords, it should not become an argument for the destruction of the Convention on Human Rights, confronted by, in our own generation, by a new breed of dictators who again threaten the foundations of democracy. It would be sheer defeatism and an act of vandalism to abandon the legacy which has been entrusted to us. So I'd like to renew my thanks to everyone who's participated in today's debate, and in closing this crossbench debate marking the 75th anniversary of the European Convention of Human Rights, thank all those who have made such excellent contributions in your Lordship's House.
Yeah. The question is that this motion be agreed to. As many of that opinion will say content. Contrary not content, the contents have it. My Lords, I have to notify the House, in accordance with the Royal Assent Act 1967, that His Majesty the King has signified his royal assent to the following Act, the Finance Act. We will now have a short break before I call the next business. Question for short debate. Support for the COVID-19 bereaved, the Lord Bishop of London.
I beg leave to ask the question standing in my name on the order paper. My Lords, as I rise, I declare my interest as the former chair of the UK Commission on Bereavement and others as set out in the register. Though we are small in number, I am grateful for the opportunity to hold this debate. I'm aware that reflection on the impact of COVID-19 is no longer a particularly attractive subject, but I feel strongly that the impact of this world-changing event will continue to be felt in the years to come. In our nation's living memory, there hasn't been a moment in which so many of us have experienced bereavement at the same time. Over the course of 2020 and 2021 alone, there was an additional 750,000 deaths that would ordinarily be expected based on the previous 5-year period. By the end of 2022, an estimated 16,700 children and young people in the UK had been bereaved of their parent or a primary caregiver through the deaths associated with the pandemic. On Sunday the 9th of March, we marked 5 years since the start of the pandemic, with a day of reflection. in which communities up and down the country remembered our national and personal loss. Many of these wounds are still raw, and the BBC reported that sobbing could be heard at the National COVID Memorial Wall. This afternoon, I would like to discuss the particular disruption to bereavement during the pandemic and also the long-term impacts of restricted bereavement. The UK Commission on Bereavement was launched in June 2021 and in October 2022 produced our report, Bereavement is Everyone's Business. The report identified a number of key ways that the pandemic disrupted the grieving process of those bereaved. Firstly, and perhaps most obviously, funerals. Restrictions meant that there were delays, restrictions in numbers, social distancing of attendees, and changes to collective end-of-life rituals. Wakes, showers, collective recitation at home, 9 nights, and viewing and embalming of bodies at home weren't possible. And as with many aspects of the pandemic, not everyone's experience was the same. Many religious and ethnic minority groups faced more significant barriers to organising funerals. Many people reported that finding funeral directors or bereavement organisations with culturally appropriate funeral services was difficult, and that not being able to participate in usual rituals prevented them from grieving properly. Being able to access a meaningful and affordable funeral was already a challenge before the pandemic and remains so afterwards. According to Sun Life's Cost of Dying Report 2025, the average cost of a simple funeral was £4,285, which is a rise of 134% since data collection begun in 2004.